Hi again, and welcome to another episode of Ask the Lawyer. I'm Rob Rosenthal with AskTheLawyers.com. On today's episode, we're going to talk about bankruptcy and specifically how it affects your vehicle and whether or not you can keep your vehicle. Here to answer our questions is attorney David Shuster of Shuster Law in Dallas. David, thank you for making some time for us today.
Glad to be here. Good afternoon.
So I'm guessing you've been asked this question before, once or twice. If I file for bankruptcy, can I keep my car?
It's one of the biggest recurring questions that everybody always wants to know. Can I keep my car? And it's also one of the most repeated questions too. Just, they need to hear it several times that yes, your car is safe. No problem.
It's just that simple?
Well, it depends. As long as you're a licensed driver, if you're allowed in bankruptcy a car for every licensed driver in the household. Okay, and so if you have, you can't have like a paid off Porsche that's worth $40,000, obviously. So there's limitations to the cars, but a car for every licensed driver in the house. Okay, and even if it's paid for and worth more than $10,000, it's not going to be a problem. And most cars, as you know, driving around on the road don't have that kind of equity. So really what the Chapter 7 bankruptcy is after in losing vehicles is going to be just, that side sports car, that extra Jeep that you use to get to the lake. I mean, it's kind of the obvious stuff, right? I mean, you can't file a Chapter 7 here in Texas and in most cases keep just an extra recreational vehicle, although sometimes you can. Okay, every situation is different. A lot of times you can find room to exempt that as well. But certainly, if you've got your college kid living in the house and they've got that paid for Honda Accord that's worth $8,000, and then you're driving a car worth $10,000, both cars you keep. You do not lose the car as long as you have a licensed driver in the household that's driving that car. Okay, then there's an exemption for it and you're not going to lose it.
But you still have to make the payments on it if it's financed, correct?
Listen, if I could file a Chapter 7 bankruptcy and we could get rid of the car loan and keep the car, my business would go through the roof. That would be the heck of a deal. And no. So yes, if you're making, but you can be behind on the payments, but ultimately you have to get caught up at some point. Okay. And so, yeah, I mean, if you go into the Chapter 7 and you're a couple payments behind, you won't lose your car still, as long as you're able to get caught up in the near future. But yes, of course, payments do need to be made. If you're going to keep the car, there's always a lien on that car. So, they can always come back and repossess even if they can't collect the debt against you personally.
Gotcha. What is I've heard a car loan cramdown. Explain to me what that is.
Well, that would be if you have owned the car for 910 days prior to the date that we're filing bankruptcy. And this is going to be a Chapter 13 bankruptcy. So, basically, if you've owned the car for a little more than 2.5 years, then you can put the value of the car in a repayment plan rather than the loan balance. And as you know, a lot of these cars driving around, people owe $20,000 on the car, but they could really only sell it for 12. You might find it on a retail sales lot for 15. And that's the price that you can put it in the bankruptcy plan for, is whatever they could sell it for, sort of retail, right? So it's about cramming down the unsecured amount. You're getting rid of the unsecured debt that is within your car loan because it's not worth the payoff amount. So it's essentially the tool in bankruptcy that allows you to force the creditor to refinance the car for reasonable terms. I'm going to pay you what it's worth, and I'm going to pay you at 5% interest the value of this car, and I'm not going to pay you the $25,000 for 11% that the original terms were on. And it's a fair rule because you can't go get a car under bad terms and then throw it into the bankruptcy. That's where don't know how exactly the 910-day rule was negotiated, but that it was deemed to be fair that if you've owned the car for that period of time, then obviously we're not dealing with a premeditated situation, and you're just dealing with someone who needs some help and needs the bankruptcy court to help them refinance that car.
And they're upside down in that loan, as they say.
Upside down in the loan is exactly what a cram down is meant for. If you're way upside down, it takes some time to repair. So that's when the client and I will talk about, hey, you could do a Chapter 7, but if you did a 13, you could own this car a lot quicker and a lot cheaper. So let's do the 13, and then when you're done paying for that car in the 13, then all the other debt goes away.
Are there limitations beyond the certain number of days you have to have had the car?
There are really very few, if any, limitations beyond that. I mean, obviously, you need to carry insurance on the car, make sure it's protected. You need to make those payments under the plan, so the car creditor is getting paid those payments. Probably would not allow for like a Uber luxury type car to be crammed down. Okay, I mean, it's got to be reasonable. But no, I mean, it's essentially that's it. I mean, you're driving around in a car that's upside down, and you don't have the income to pay your credit cards, nor do you have the income to pay that $600 plus car loan on a car that's worth less than you owe. Then no, there's very few, if any, limitations for just coming right into bankruptcy and just refinancing the car in bankruptcy and wiping out the unsecured amount on the car along with all your other unsecured debt.
So it would seem to me, David, sometimes that people get into cars or get a loan that they can't afford, that could be part of the problem, the reason that led to the bankruptcy. What is the solution there?
It's a big problem. Okay. I mean, I can't tell you the amount of people that I meet with that have these terms on car loans. I mean, $700 payment on one, $600 payment on another. And keep in mind, I mean, these vehicles are even further upside down because they traded them in originally on a formerly upside down loan, right? So they basically took the negative equity in their car. Oh, sir, would you like a new car? Okay, well, you're going to have to pay us $3,000 for us to pay off your former car loan, right? And so it gets really egregious when you really kind of look at some of this, and you look at these poor people that are out there struggling, just trying to make ends meet, and they have a $44,000 car loan for a car that they couldn't turn around and sell for 20. I mean, it's just really something else. And so it's a really good provision in the Chapter 13 bankruptcy that allows them to own the car for what it's worth as opposed to these horrible terms.
Gotcha. David, thank you so much. Very helpful information. I'm sure you helped a lot of people today. I appreciate it.
Okay, yeah, my pleasure. Thanks.
That's going to do it for this episode of Ask the Lawyer. If my guest has been Attorney David Shuster of the Shuster Law Firm in the Dallas area. If you want the best information about bankruptcy, or you're ready to choose a lawyer that lawyers choose, make sure to visit askthelawyer.com. Also, please subscribe to our YouTube channel by clicking on the button at the bottom of the screen so you don't miss any future episodes. Thanks for watching. I'm Rob Rosenthal for AskTheLawyers.com.